Good afternoon, colleagues. We want to get this hearing started. We have 4 brief hearings today, I think with 1 to 2 witnesses apiece. The first one is Senator Simon Eyre. And go ahead, sir. You may begin when ready.
Thank you. It's a pleasure to be here. For the record, Senator Simon Eyre presenting Senate Bill 147, Stationary Engineer Board Appointment Clarifications. I'm an engineer by trade with computers. When I first saw this area, and they said stationary engineers, I thought it was just engineers that didn't move much. But what they actually do is they protect the public, they provide for safe operation of power plants, plants of machinery and boilers, and they promote high professional standards. And I wanted to thank the Department of Labor and the AG for working with me on this bill over the interim. There's no opposition, no fiscal impact, and it's supported by the Department of Labor. So this bill clarifies in law what is happening in current practice. It simply adds the word consent to the appointment process in law, which was inadvertently left out. Today, the Board of Stationary Engineers are appointed with the advice and consent of the Senate, but the process does not align with current language in law. For example, last year, there were 3 members appointed to the board through the advice and consent of the Senate. However, the word consent was left out in law, and it just says the advice of the Senate, which appears like that nowhere else in law and really has no practical meaning. This language aligns with 200 other occurrences where it states the board member is appointed by the governor with the advice and consent of the Senate. This is simply clarifying the appointment process to match current practice. Specifically, it just adds the word consent to the Business, Occupation, and Professionals 6.5-202. And in fact, if you go to the Department of Labor's website for the application, they actually have this law on their website, and they have the correct language, not what's in current law. Now, this cannot be updated with the annual corrective bill because technically it changes policy, even though it's just aligning with current practice, hence the bill. There's no opposition, no fiscal impact, and supported by the department. I ask for your favorable consideration.
Thank you, Mr. Chair. Quickly, this just allows the Senate to confirm somebody, essentially?
Basically.
Yes. Why would the House do that? There's no opposition over there.
True, true. I hear you, I hear you. My daughter served area, so I understand.
Well, we appreciate this gentle grasp for power. Certainly, you know, this time of the year, the House and the Senate are just wedded like this. So yes, we will definitely get the bill for consideration, though, Senator. Thank you very much. And also thank you for being on time. I wish your colleagues could be the same way, but I appreciate you.
All right,
thank you
so
sir.
Much.
I don't know. Is there any representatives for Senator Reedy, Senator Lamb, or Senator Charles?
I'll present the Lamb.
No, you won't. All right, we will patiently wait for the senators to show. It feels like it's going to go that way. Senator Charles, we appreciate you respecting the time of the House as always and coming on your own terms. If you'd like to get this bill hearing started, I'm sure it'll be successful. Go ahead, sir.
Never forget where I came from. I love all my House friends and family over here, especially our great chair of ECM. And I see he shaved his beard. Thank you. All right. Good afternoon, Chair Wilson, Vice Chair Crosby, and honorable members of the Economic Matters Committee. For the record, I am Senator Nick Charles, representing Legislative District 25, and I'm testifying in support of Senate Bill 522, As amended, the bill requires home builders to provide written warranty information for all appliances, including heating, ventilation, and air conditioning HVAC systems registered by the builder at the time of closing for the initial sale of the home. I proposed this bill because I had a constituent who came forward, and it's to create transparency from home buyers and strengthen consumer protection in the housing market. Purchasing a home is one of, if not the most significant investments a person will make in their lifetime, so it is imperative that buyers have access to complete information about the products and systems in their new home. Senate Bill 522 ensures that home buyers are fully informed about the warranties on appliances like HVAC systems, which may have long-term coverage. Without this information, buyers may unknowingly purchase a home with an appliance that have limited warranty left. For example, a home might come with an HVAC system that has a 5-year warranty, but the buyer could find out that there are only 2 years left, having no idea the appliance was registered 3 years in advance. This bill ensures buyers are caught up and not caught by surprise. In Maryland, home builders have a responsibility to ensure the quality and durability of the homes they construct. However, many buyers are still unaware of the specific warranties associated with appliances until problems arise. Senate Bill 522 takes a proactive approach, ensuring the warranty information is provided in advance as part of the closing process. This eliminates confusion and avoids frustration from the buyer. In conclusion, I urge you to support Senate Bill 522. This bill aligns with the values of transparency, accountability, consumer protection, and is much needed piece of legislation for Maryland's housing market. If passed, Senate Bill shall make a favorable impact on our state, and I ask for a favorable report. Thank you.
Thank you, Senator. I wanted for some clarification points. I want to make sure that you're not, clearly you're not asking the builder to provide a warranty, just the information on the warranty.
Just the information on the warranty.
And in addition to the point you brought up, so I believe that the way you proposed it, I guess with an HVAC system, and I guess the thought process is it took them 3 years to build a house. So the HVAC system only has 2 years of warranty left on it. Is there some concern at that point? Does the owner have any legal actions that they can take if they find out there's only 2 years left on a house that they've already contracted to build?
No true legal action will be available at the moment, but they at least need to know that 2 years are available left on this warranty. A lot of folks, they don't know sometimes, so folks go out and buy extended warranties, and this will at least put them in a position that they can actually buy that extended warranty and be protected for the long-time coverage of the house.
Okay, thank you. Doug and Aaron's.
Thank you. If some of the bigger builders, they buy it in bulk, mass bulk. And based on what the chairman just said, that AC unit, who registers that? Don't I register that at the time I purchase the house?
You can register at the time you purchase, but typically some of those, if you look at some of the language and the warranties, they say by the time you have to register within a certain amount of time of the purchase of the actual unit itself. And so if it's not registered, then you won't have the warranty in place. And if it is registered, you at least want to know how much time is left on the warranty for the house since it was registered.
So based on the questions that were just asked, I could buy a house and a warranty's for 5 years, and by the time I get in that house, I only have 3 years left. Does the builder have to notify me I only have 3 years left, or who does that?
They would have to, if this bill passes, they would have to notify you ahead of time that, hey, you only have 3 years left. And then, there's other options there when it comes to buying an additional long-term insurance policy or warranty policy for your house. So I pay an extra fee outside for my house that covers all my HVAC and everything.
You're paying extra for that. I'm buying a brand new home, though. I'm buying a brand new home.
And some people buy those on brand new homes also.
Well, I get that, but I don't typically want to. But I guess notifying me is a step that they got to be actually aware of that, first of all, the builder.
Correct.
And you're putting it on the builder. What happens if they don't do that and I don't get notified? And I look at my new GE AC unit, it says I got a 5-year warranty. I go back, I'm 3 years into it, and I find out, or I'm 5 years into it, I don't have a warranty anymore. I've only lived there three of the 5 years.
Well, that's happening right now. So what this does is it forces the builder to tell you right now, as soon as you buy this house, hey, you got 2 years left.
Builder's liable.
The builder's liable. You have 2 years warranty left on this house. So
Thank you.
To be clear, what is the enforcement mechanism if they don't?
So there is no enforcement mechanism right now. Yeah. I would love an amendment from the House if you guys want to.
I just want to make sure that, so the Senate passed over a bill with no teeth, because it sounds like the bill is just, I would argue, virtue signaling at this point, because if they choose not to abide by the rules that we're putting in place, that the Senate has already passed out, we have no recourse.
Listen, I'm more than willing to work with the House to come up with an amendment that adds teeth to the bill. I'm definitely willing to do that. Like I said, this came from a constituent, and I think it's a real issue that needs to be addressed. And to your
What
point,
committee did this go through?
this came through, I believe, Triple E.
And nobody brought up the enforcement mechanism in Tripoli? Is it finance?
Finance?
Went through
No, finance.
No, you're doing great, Senator. You're doing great.
One of 22 bills that I've had, you know.
So, no, obviously, we don't need you to be the subject matter expert on every bill that you put in. It was just kind of shocking that there is a bill that crossed over with zero enforcement mechanism. And I'm concerned, obviously, with the inability for us to, once we tell your citizens that they're now being protected, to have no way of actually protecting them if the builders choose to just dismiss this. So I guess we'll look and see what our subcommittee can do, because I say that with chagrin, because I think the bill hearing may have been different if we would have put some penalties in. And while we don't, was there any opposition? None that we noticed. Right. There may have been opposition if this bill was properly drafted to where we could actually use it for the benefit of the citizens. And so it's difficult sometimes to midway through amend a bill after its public hearings when it didn't get, I believe, would be a fair public hearing, because the builders may have more of an input if we told them there will be some fines or charges, or as y'all like to do, misdemeanor penalties with jail time guaranteed if they violate it. So I'm just concerned with how we go forward without letting the public have a true opportunity to have weigh in. But that's all.
Understood.
Well, thank you very much, Senator. I believe we're moving on. And before we do, I'd like to introduce my foster shadow today, Kanaya, and Brianna, her case manager. They're sitting behind us. And Senator, you can keep it moving. Get on out of here, buddy.
Are you kicking me out?
I'm not kicking you out. I'm just asking you to leave. No.
You sound like Martin Lawrence right now, man.
Senator Lamb, there you go. You're next, sir. Go ahead with your bill. And you have you have one virtual witness. Is that correct? He's not part of your panel?
I believe so.
That's fine. We'll get him. Go ahead, sir.
So good afternoon, Chair Wilson, Vice Chair Crosby, members of the Economic Matters Committee. For the record, Clarence Lamb, Senator District 12, requesting a favorable report on Senate Bill 578. This bill was voted unanimously out of the Senate Finance and also out of the full body. This bill alters the Maryland Home Improvement Commission's Guarantee Fund statute to allow MHIC more flexibility in awarding eligible claimants and giving them the ability to award attorney's fees from the fund at their discretion. The Guarantee Fund allows people whose homes have sustained damage due to poor contractor work to more easily be reimbursed for costs spent on the project. The fund is funded by contractor licensing fees as well as reimbursements by contractors against whom MHIC has found that homeowners are permitted to recover. Depending on their contract, a homeowner may undergo arbitration or an administrative pathway to determine their eligibility for disbursement from the fund. The problem that this bill seeks to address is that some homeowners' arbitration orders do not sufficiently identify, quote, actual losses under the Guarantee Fund statute that MHIC will accept them for reimbursement. So homeowners have gone through arbitration and potentially appeals and are still unable to access the fund and potentially are back to where they started. By removing the word expressly, quote unquote, from the statute, our goal is to broaden their discretion and enable them to accept more arbitration awards. This approach is consistent with Brzezowski versus Maryland Home Improvement Commission. This legal case in which the Appellate Court of Maryland, at the time the Court of Special Appeals, determined that an arbitration award must substantively state that actual losses were sustained rather than expressly stated for the commission to award money from the fund. This bill seeks to put that finding in statute to clarify the legislature's original intent. The second problem this bill addresses is one of attorney's fees that homeowners may incur. While many are able to go through proceedings without the need for an attorney, some homeowners are facing arbitration and appeals of arbitration orders. These appeals must oftentimes will result in hiring attorneys to handle their cases. By permitting MHIC to also award attorney's fees from the fund, this bill reflects the reality that for some consumers, accessing the fund can be a cumbersome legal process that may involve multiple levels of appeals and greater expenses than anticipated. I also want to call attention to the bill's fiscal impact, which is minimal and can be implemented with existing resources. MHIC estimates that expenditures may cause license fees to increase by $5 for new licenses and $9 for renewals if payouts increase 5% to maintain the fund at its statutory levels. Again, that's a may. While we don't want to penalize good actors for the actions of bad actors, this is a nominal potential increase, it may not even be that amount, that could ensure that the fund can make more homeowners whole, for which was its purpose. So that's the bill. Thank you for your time. Happy to answer any questions.
Thanks, Senator. I do have a question again when we're talking about, I want to make sure that I'm getting an understanding when the Home Improvement Guarantee Fund. So basically, this is when a home improvement was either done incorrectly or not at all, correct?
Correct.
Now, I'm curious, what scenario would attorney's fees arise and not be paid for by the contractor? Because I guess that's where I'm stuck at when I hear the bill. We talk about arbitration. This is with the contractor. I would have assumed any award that's brought out through arbitration or after the appeal process will be borne by the contractor that was at fault and found to be at fault. So when would they be using this fund if we have a contractor that's actually brought to court?
When would we be using the fund if we've had a contractor brought to court?
Right, because the fund is only for, to my knowledge, is when you don't have a viable contractor, you can't get them, and then you just have to prove that these damages were done, either done or incurred duty or the faulty installation or they didn't come and finish the job, and then you go take it to the this board. So I don't understand when the attorney's fees, because to me it seems like if there's anything to do with an attorney, that you have somebody on the other side that you're suing, because that would truly be the person liable. And most contractors, I believe, are the ones liable for any work that they don't do correctly. So what scenario would there actually be attorney's fees that the fund would even be able to dip into? And I'm not trying to catch you. I was just assuming you had a specific scenario for this, because I just don't envision when you'd use attorney's fees, because if there's attorney's fees, there's a contractor. You're suing somebody.
Right.
This board and fees structure was created for when basically the fly-by-night, the people that disappear, the people you thought were home improvement actors, but they were not, and then you get some of your money back. But if you have an attorney, I'm assuming that I just don't know when you wouldn't.
I think they can come out of the fund also if there's some dispute of some sort, and that's why it can end up in arbitration.
Right, but after arbitration, that's what arbitration is for, is the dispute. Ergo, you have an attorney, there's an arbitrator, they come out with a holding, and either it's appealed, whatever, but meaning the holding, let's say it's against the contractor. Well, then you would get your attorney's fees, and you would get, I would assume, whatever the holding was from the actual contractor. This fund was put in place when we couldn't get the contractor, when there really was, you were just a victim with really no defendant. So I'm just trying to figure out where this works in at. And I'm not trying to put you on a spot. I just didn't know if you had a specific scenario, either rationale behind this.
This bill actually came about because a constituent brought a concern directly to us.
Okay.
That they were not able to, because of the expressly clause, not able to have the claim dealt by the guarantee fund, right? And because it went to arbitration, and then because of the expressly clause that's in there, they weren't able to access the funds or receive those funds. That's why we're taking that out. And then they also, there have been instances where people have had attorneys to help bring the case to arbitration, to bring it to attention, and they have not been able to get those attorneys' fees.
And I always say this because I am a plaintiff's attorney and I don't trust me. So my curiosity is twofold, is again, my first question. Also, are there going to be limits to the attorney's fees, what we've considered reasonable or not? And in the bill, do you have any, is there any, you do envision limiting the attorney's fees to either a certain amount, a certain percentage of recovery? And again, I'm just kind of trying to figure out what the direction the bill's trying to take.
It does state in here that the amount of the attorney's fees greater than the amount awarded for the actual loss resulting from the acts of the contractor, provided that the total amount awarded to the claimant does not exceed $30,000. So there's.
Wow. Because that's always my concern too.
But that's the total,
No, I understand, but like that is my definite concern that sometimes, you know, there's a $6,000 loss and I got $24,000 of attorney's fees, which is why most business owners get terrified. It's not because of the actual loss that they may have to pay out, but after attorney's fees, it's $30,000, and that somehow a small number could equal into a very large payout for a very unscrupulous attorney. That's all. So these are, I just want to know if you had any answers. That's fine.
Yeah, I'm happy to look at, you know, limitations on that. I think that's reasonable.
And we do have one virtual. Sabin Swickard.
Yes, he's actually the constituent that reached out.
Yeah, that's what as I look, I was hoping maybe he'll provide the answers. Yes, ma'am.
Can you hear me?
Yes, ma'am. Go ahead. I got you.
Mr. Wilson, I heard a lot of your questions and I can pretty much answer all of them. I'm going to go ahead and give my testimony, but if you can give me like 3 minutes. I tried to condense it down to 2, but give me 3 minutes, and then if you let me, I can answer all of your questions. So let me start. So MHIC has been construing statutory language that applies to the codes and regulations they adhere to, and according to their own exclusive in-house interpretation of those applications and those regulations and codes, thereby categorically preventing Maryland arbitration and the judicial system from intervening and or establishing how these codes and regulations ought to be interpreted, especially when MHIC themselves assigns cases to the Maryland arbitration and judicial system for rulings due to contract clauses between contractors and homeowners. In instances where binding arbitration and judicial decisions diverge from MHIC's favored interpretation, MHIC reserves the authority to disregard legal rulings, compelling homeowners to initiate a fresh process with the Office of Administrative Hearings. This action effectively restarts the appeals process, thereby extending an already protracted procedure and imposing significant legal expenses on homeowners. MHIC has been disregarding binding arbitration and judicial rulings that extend all the way to the Court of Special Appeals for decades, and this behavior stands in direct contrast to the very intentions of the legislature that established the MHIC. And in my particular case, I was forced into arbitration by an MHIC investigator who misinterpreted my contract. This investigator denied my request for a hearing with the Office of Administrative Hearings, as he mistakenly believed my contract contained an arbitration clause, which it didn't. Following the advice of the MHIC investigator, I sought an arbitrator through the Office of the Attorney General, and one was appointed to our case. After prevailing in arbitration, and we won the appeal because the contractor appealed it, this also followed with victories in both the civil and the appellate court. And the appellate court even referenced the Brzezowski and MHIC case when rendering their opinion. Despite these favorable judgments, MHIC refused to recognize our victories in a court of law, including those rendered by the very arbitrator appointed by the Office of Attorney General, who was well aware that they were overseeing an MHIC matter and who should have understood how to rule on the case when they were ruling in our favor. Ultimately, my initial grievance of $13,000, which had originally been awarded to us when our cost was roughly at around $1,500 in attorney fees, and we were only at about a year into fighting. We've now been 6 years in at $50,000. We just went to our OAH hearing this month to start all over again. MHIC permits unqualified individuals to misguide homeowners regarding the mismanagement of their complaints, resulting in losses amounting to tens of thousands of dollars. To exacerbate the situation, they consistently disregard the decisions made by arbitrators employed by the same agency that also retains their legal counsel. And how can these arbitrators lack the necessary education to issue appropriate arbitration decisions pertaining to MHIC cases? And furthermore, why is MHIC allowed to ignore legally binding rulings? And why must homeowners resort to litigation in order to get MHIC to comply with their own regulations and codes? This government body has exploited Maryland residents for too long under the pretense of interpretation. They are allowed to make the most egregious and costly mistakes, all without consequence, while the homeowners bear all the financial burden. And what's even more disturbing is no action has been taken to halt this practice, resulting in millions of dollars lost by homeowners over decades.
Thank you very much, ma'am. It sounds like your grievance is very much with MHIC. I just wonder, did you ask for attorney's fees with any of your litigation?
So,
and try to make it a short answer if you can.
Yes, I did.
And did the judge approve your attorney's fees?
I'm sorry?
Did the judge who heard your case approve your attorney's fees?
Yes, at the civil level.
Correct. And so you were able to recoup your attorney's fees?
No, sir.
So the judge did say that you awarded attorney's fees, right? And the contractor was not required to pay them?
So, as short as I can give this, we were awarded the attorney fees, and during the 6 years of litigation, the contractor closed up business, used the exact same license number, went back to MHIC, and started a brand new business with the exact same license number, and now does not have to pay any of the awards that he was forced to pay under the old business, even though it's the exact same license number for a brand new business.
And so, and because they went,
allowed that.
And so they now went, because they went bankrupt, now you believe in kind of what the fund was set up for when someone absconds, during either proceedings before or after, that the loss that you've incurred should be paid for out of this fund, correct? Yes.
Yes, it's under the same license number.
No, I got you. I just wanted to make sure I clarified, because you did clarify some things for me. Senator Lamb, did you reach out to MHIC about this?
Our office did reach out to MHIC.
And did you get what you felt was a proper response?
I think we were concerned that this constituents issue was not addressed.
I'm saying, after speaking with them, were you satisfied with what their resolution was? Because it sounds like there's a lot. Yeah, because it sounds like a horrible MHIC problem, and I don't know what would be the point of us writing anything if they're not going to follow the laws we've already written or interpret them their own way. So I just was real concerned. Again, I say this because we don't have a lot of time left, but this seems like a very big MHIC problem. So did they come to your last hearing, to the hearing for this bill?
They did not come to this hearing for this bill on the Senate side, no.
Well, that's a problem. And did they put anything in writing? Did they have a standing on this bill? Do you remember? I know you got probably about 250 bills over there, so this is going to be hard for you.
I don't remember offhand.
That's fine. We'll find out. I'm not comfortable with doing something until we find out what and why, because it sounds like an MHIC problem.
Real quick?
Nope,
Mr.
that's all right,
Wilson?
man. Wait, there's a question posed, but
I'm
give me a minute. Thank you. So I just didn't know what I guess my question to you, Senator, is do you feel that this legislation will satisfy the problem, not just this constituent? Because it sounds to me like there's a bigger problem going on here than merely who's responsible for attorney's fees.
Well, I think it also, by removing the expressly part of it, helps with making sure that there's clarity in what can be awarded to these individuals.
Okay.
So there's two parts to the bill. So the attorney's fees is one part. The other part is removing expressly out of the statute to align with kind of what the Court of Appeals case came to.
And is that Court of Appeals case in your written language?
Yeah, it's
I believe you. I just want to know if it's there for my
versus-
attorneys to rely on, because I will be bringing myself or my subcommittee chair will bring MHEC to answer for all this. And now that we have the background, it's much more clear.
Yeah.
You know, that there is a bigger problem than merely briefly fixing some legislation. So
It's Brzezowski versus MHIC.
there we go. Delegate Weibel?
Thank you, Mr. Chairman. You need not be represented by an attorney to file a claim with MHIC, correct?
You do not.
Okay. And then MBIA, are they still opposed to the bill, or did you satisfy
We've
them?
reached out to them. I think they have a fundamental misunderstanding of what the bill does, because it talks about raising caps and whatnot.
Right, so-
And we've reached out to them several times to try to get that clarified, and we
Your
have.
bill does not raise the.
Right, it doesn't raise it a cap. So I think a lot of the points that MBIA are bringing up aren't actually to the bill itself.
Well, they are concerned about the assessment going up if you're allowed to recover attorney's fees, which is legitimate, I think.
Right, right. So yes, potential increase in the assessment going up depending on how much, is pulled out of the fund. Okay.
All right, thank you.
Delegate Aaron's? No, I'm good. Thank you. You good? Not really. I'm sorry, I believe that's all the questions we have, Senator. Thank you very much. I know I have to step away. I think the last bill's on your subcommittee.
Good.
All right, last one on the list, Senator Reedy, SB 785. Welcome.
Thank you, Madam Chair. Nice to see you.
Nice to see you.
Senate Bill 785, Senator Justin Reedy here to present Senate Bill 785. And this was brought to me by the Human Resources Association. I have a constituent who's very involved with SHRM is the acronym. And so it's a technical correction to the Maryland's parental leave law. And let me just be clear, we're not talking about paid time off or paid sick leave. We're talking about unpaid parental leave. We passed a law in 2014 to require a certain amount of unpaid parental leave for businesses under the FMLA cap. So if you're a company with 50 or more employees at the federal, if there's an FMLA that applies to the federal level that gives unpaid leave to all parents. We wanted to try to provide a covering underneath of that, and we did. So this is a technical correction. It took many years for the regulations to be promulgated, and the reason they're only coming to us now is because probably the regulations took several years to fully be promulgated, and then it took a few more years with the little pandemic thing that we had too. So this is why it's so 10 years later I'm coming to you with a bill on behalf of this organization. But currently an employer can be covered under both the law for employing at least 50 employees at the same time as being covered under the law for employing 15 to 49 employees. And it's an unintended consequence, we're pretty sure, of the law as it passed. For an example, an employer crossed the 50 employee threshold in January of 2024. The employer will now become an FMLA covered employer in June 2024 after employing at least 50 employees for 20 or more weeks. But the employer will still be covered under Maryland's parental leave law through December 31st of last year because it employed 15 to 49 employees for at least 20 weeks of the preceding calendar year in 2023. So it leaves it to where you could potentially be faced with can they stack under the law? So how are both leaves supposed to be administered if you're a human resources professional or if you're a small business particularly? Is the leave stacked or does it run concurrently? If the leave is stacked, which leave should be administered first, the 12 weeks of federal or the 6 weeks of Maryland parental leave or vice versa? Does the answer depend upon the reason leave is taken? There's different variances there. It's all in my testimony. I won't bore you by reading the entire testimony, but Maryland's law provides 6 weeks of leave to be provided in any year, but does not identify who chooses or defines the year, while FMLA permits the employer to choose any 12-month period, such as a fiscal year, calendar year, forward or backward rolling year. So the right to job restoration is much more generous under our law than FMLA. So again, if the leave runs concurrently, it becomes very, very confusing. So the bill amends the language to allow employers more clarity on the law. And I'm happy to take any questions. It really is a technical fix. And in the bill on page 2, it's employer means a person who, one, either employs 15 but not more than 49 individuals in the state for each working day during each of 20 or more calendar work weeks in the current preceding calendar year. That's all current law, but then this adds an and is not covered under the Federal Family and Medical Leave Act for the current calendar year. So that's the change. It's just and is not covered under the Federal Family and Medical Leave Act for the current calendar year. So it avoids there being just a lot of confusion, and apparently there's been some. So that's the bill, and I would ask for favorable support and happy to answer any questions.
Thank you, Senator. Before I turn to Delegate Pepe, just for my own understanding, this only applies to employers with 50 or over employees.
Yeah, so FMLA is 50 or over,
Right.
and then our law applies if you have 15 to 49.
Yeah, that they have to contribute into our state law.
Right. They have to provide that unpaid 6 weeks.
Right.
Yeah.
Okay. All right, Delegate Pepe.
Senator, good afternoon.
Hey.
All right, so basically, someone starts off the year with 49 employees, and then they hire a few folks. Now they're at 50. And this bill goes to, I guess, solve the issues. If you transition over to 50, then there's some requirements. But what you're saying is you're covered, like the dates don't match, and so this could fix that. So my question is, if we have an employer that switches over the 50-person threshold, does this bill remove the first half of the year requirement, or does it remove the second requirement if you transition over to 50?
I think what the bill says is that if your employee can still be covered under the FMLA provisions, then
you should stay there for the year.
You should stay there for the year.
Got it. Okay. All right. That sounds like a good fix. Because right now, it's like the SAC, you said double, you essentially double coverage. And then how does that impact the employer if there's double coverage?
Well, I mean, it's a couple things that I put some of it in my testimony, but sometimes it can be, do I have to then give them 18 weeks off?
Okay.
Do I have to hold their job for longer than 6 weeks under our law versus 12 under the FMLA? And our law was more generous in saying you have to hold the job longer and some other things. So it just becomes very confusing. And I don't think this is afflicting hundreds of businesses, but there's probably several dozen businesses that have run into this as they scale up and scale down right around that 50-person
And the
limit.
requirements for the business are different, 49 and under, and then 50 and over. And so
Right.
if you have someone that switches over, there's going to be confusion. in this.
Correct.
All right.
Correct.
Sounds like a good bill. Thank
Yep.
you. All right.
Senator, I'm just curious if the Department of Labor was involved in this in some way.
There was no opposition from them. I think they were fine with it as a technical fix.
Okay.
But I don't know that I have testimony in the file. I can double check that.
Yeah, I'm not seeing, I'm just curious if they administratively, because they are right in the middle of all of these things. Thank you.
I think it was a situation where when they promulgated regs for this, they didn't promulgate regs for a little while, and then kind of it came out, but then we did some other stuff with paid leave and paid time off, and then we had the pandemic, so that it just kind of all of a sudden people are realizing, oh, wait, there's this little technical snafu. Yeah.
Great, thank you very much. Any other questions? All right, seeing none, this concludes the hearing
Thank you.
for today. Thank you. Senator, the staff has a question for you, if you don't mind.